You're listening to Soundside. I'm Libby Dankman. Police have one 15-year-old suspect in custody in connection to the mass shooting at Seattle Center on Sunday. Earlier this week, a King County Superior Court judge found probable cause for 3 counts of first-degree assault and a single count of second-degree illegal possession of a firearm. The suspect remains in juvenile detention. An arraignment is scheduled for Thursday when the defendant will hear charges filed against them. But the legal process may become more complicated due to the alleged suspect's young age. That's also why we and other news organizations are not naming the suspect. To explain what will happen next in this case, I'm joined by Mike Diaz. He was a King County Superior Court judge from 2018 to 2022 and served a term as a chief judge of King County's Patricia H. Clark Children and Family Justice Center. Former Governor Jay Inslee appointed him to the Court of Appeals in 2022. Thank you very much for being in studio.
Thanks, Libby, for having me. I'm thrilled to be here.
So before we jump in, I just want to note, so you are running for position 3 on the Washington State Supreme Court. This is not a campaign stop. You are an adjunct professor of law at Seattle University, this law school there. You also taught juvenile law at the Washington Judicial College. So we're talking to you about the workings of juvenile court and generally informing listeners about what could happen in this major local story. Sound good?
Correct. And I'm taking off my campaign hat, and I'm setting it far aside, and I'm putting on my old juvenile court hat. And I appreciate you specifying that we're talking about it generally, because I also serve on the Commission for Judicial Conduct, which has rules, and some of the rules include not commenting on pending or impending cases like the one you just referenced. So nothing I say should be any indication about my views on that case, the merits of the case, what may happen in that case. This is all just general administration of justice, which I'm perfectly allowed to talk about.
I appreciate that. So I mentioned that there is an arraignment happening Thursday for a 15-year-old suspect. And while you were sitting on the bench in juvenile court, you must have seen cases come across your desk that involved young suspects like this. And I wonder if you could just share, first of all, how you approached as a judge, especially young kids who were accused in really heinous crimes.
I mean, number one is we want to get through the case, right? And we want to get through the case safely for everyone. That includes the kid who's accused of an offense. An offense is what it's called a crime if he had been an adult, and the alleged victim and anybody else involved in the process. The first part of that, just getting through the case, is just guaranteeing due process. And the latter part really is how can we ensure that the community and all of our staff and all people touching this are going to be safe from point A to point B of the process. The vast majority of young people that come into our court are in need of services, as often are the families of the child too. And the services ensure that the safety of the public and the young person themselves. And the court can play a helpful role in motivating a kid to accept and work with the services even before the case goes to trial, which we call fact-finding in juvenile court, let alone disposition, which is what we call sentencing if they are found to be culpable for the offense. And really we work, that's what really one of the most distinguishing features of juvenile court, in state court at least, juvenile court versus adult criminal court, is that we have pretrial services essentially, and we have people like counselors, like psychologists, like substance youth therapists who come in and try to identify if there is an issue of any of those issues and try to stabilize the situation and provide services sometimes for the first time ever in this kid's life. And what's the court's role is providing, the support system so that the youth is held accountable to those pretrial services in the sense that they can making sure we can comply and keep the kid and the victim and anybody else safe, but then also allows us to get through the process as efficiently as we can. And that sometimes means that we also hold other players accountable. Maybe it's the school, maybe as an IEP, a plan that is specifically tailored to that young person's need, but the school isn't following through. So we have some authority to ask questions and can lead and change his behavior. I analogize it to air traffic control. There are just so many things going on in this child's life often, which can be tied to this behavior, that we need to diagnose it in a professional, scientific way, and then try to begin to remedy it even from the beginning of the case, if the young person and their lawyer and their families are so inclined.
I noticed that you corrected me about the way that you refer to charges in juvenile court. So you say offenses, or as I said, accused of crimes, basically. So these kids in juvenile court, they're accused of offenses instead. And I think that speaks to just like the way that this diverges, just one of the small ways it diverges from adult court. Could you maybe speak more? You talked about the pretrial services. Are there other ways, big and small, that juvenile court and adult court diverge, and how they treat the people that are going through them?
Yep. Juvenile court was originally viewed as a place where we treat kids differently than we do an adult criminal defendant, and that includes the terminology, as you point out. It's a crime is called an offense. The defendant is called a respondent pre-adjudication, and even when they're convicted of the offense, they're now called a juvenile offender. That might follow what we called a fact finding instead of a trial, and like I mentioned, a disposition instead of a sentencing. Conceptually, the idea is that maybe even more than adult court, we are charged with, and this is both under federal and state law, we're charged with balancing, yes, the need for accountability, but also with the desire for rehabilitation. And sometimes those things sound like they're in conflict, but we never view them as conflict. Holding a kid accountable is part of the process of rehabilitating them. Providing them services is actually a crime-fighting measure. It allows kids who have, a serious undiagnosed mental health issue. And when I mean serious, I mean we have kids who have, schizophrenia. We have kids who have really severe, debilitating bipolar disorders. They've never been treated by anybody. And by being able to treat those, whether, beginning that process, pre-adjudication, or after the trial, we actually are preventing crimes that might happen down the road. And it's all very, very fact-specific, but it's this twin goal laid out in our law. It's been there for decades now to balance both accountability and rehabilitation. So it is in some ways, kind of what we should be doing perhaps in adult criminal court as well, making sure that people are being rehabilitated and not just being punished. But it is definitely the focus of juvenile courts around our state.
So walk me through what generally happens in a case like what we're talking about at the Seattle Center, the shooting suspect who is 15 years old, being held in juvenile detention right now. The judge found probable cause to hold this minor, and the offenses that were talked about were first-degree assault, a single count of second-degree illegal possession of a firearm. And so that gives the court the right to hold this kid for at least 72 hours, is my understanding. Now, what happens at an arraignment? What's going to be coming up on Thursday?
Yep. And so an arraignment is the formal reading of the charges. So yes, you're right that at what happened in the first incident, at first appearance, was the judge made a decision as to whether or not there was enough evidence to hold the person for a short period of time. Now, at arraignment, the state has to bring formal written charges advising the young person about what offenses or crimes they're being charged with. And then the young person has the opportunity to essentially plead not guilty, plead guilty, or some other version of that. And so that's what's going to happen in arraignment. And with that, there will be likely another decision on whether to hold the young person pending the trial. I mean, the criminal process is relatively simple. After you learn of the charges, the next step should be trial in some ways. But then there's going to be a lot of information that has to be acquired by both the defendant or the respondent here and the state to make sure that they get a fair trial at the end of the day with all the information that they need. Typically, for very serious charges, it depends. The age matters a lot. So you have a juvenile court has jurisdiction over certain kinds of crimes, and it kind of depends on the age of the young person. The Washington law has what's called auto adult decline. So if your age is, say, 16 to 17, and you've been either the offense charged alone is a serious violent offense, right? A completed or attempted homicide, assault 1, kidnapping, rape in the first degree, or the offense charged is a violent offense, that those are terms of art, and the young person also has prior criminal history, which is laid out in the statute, then then automatically has to be charged as an adult.
That young person there's no extra appeal by the prosecutors or anything that has to happen. That is just automatically bumped to adult court.
Exactly. And that's for 16 and 17-year-olds. And then the transfer to adult jurisdiction is automatic. The juvenile court never sees those cases unless they're later resolved in a way that puts them back in juvenile court jurisdiction, under a lesser charge or something like that.
So that is for the cases that are automatically moved to adult court. But then for something involving like a 15-year-old suspect, that is a situation where prosecutors can request basically to try a case in adult court. That is something that can happen with a 15-year-old suspect who's accused of very serious offenses, right?
That's absolutely correct. It's called discretionary decline, and the discretion lies with the juvenile court judge who will preside over that motion, essentially. It's a prosecutor asking the court to do something, which is to decline jurisdiction. And that it can be sought for people who are under the age of 16 who are being accused of, a serious violent offense. That's a term of art. I kind of laid out some of them earlier, and a couple of other cases. And what makes it complicated is that the court then has to look to what are called the Kent factors. That's a United States Supreme Court case, U.S. versus Kent, to determine whether or not there's a basis for keeping the young person under juvenile court jurisdiction as opposed to adult court jurisdiction. So we're looking at the nature of the offense, essentially, right? Was it done with aggression? Was it premeditated? How serious was it? We're looking at, how desirable is a trial in this case, and the disposition in a single proceeding. For example, if some of their co-suspects are adults. We're looking at the sophistication. This is really where you start getting into needing a lot of information, the sophistication and the maturity of the juvenile, right? And you're looking at the juvenile's home, their environment, their situation, their emotional attitude, their pattern of living, their prior criminal history, if any. And then you're also looking at, and this is a big one, none of them are like dispositive in the sense, none of them will alone answer the question whether or not the court should decline jurisdiction. You're looking at it very holistically. But the final one is whether or not we would provide adequate protection for the public, and what is the likelihood of this juvenile being rehabilitated. And there are situations where some juveniles, because of a lot of different things in their lives, really are going to have a higher, longer road to get to a place where they can be safely released into the community. And so what you end up having then is a lot of experts come in. They're both on the defense side and on the state side, opining on all sorts of things about the crime, about the juvenile's background, about the safety of the community, about other things that are just out there in the world at this time. And so what ends up happening is it's not mandatory, but most of the time you end up having a kind of mini trial on this, where the state has to show, kind of more likely than not, that these factors weigh in favor of declining jurisdiction, otherwise for it to go to the adult court. And at the end of the day, the trial court then has to write up their reasons, and they have to explain why it's in the best interest, and this is straight from the law, best interest of the community and the juvenile to decline jurisdiction. And it's understandably a long process, because usually these are extremely serious charges that are being brought against the juvenile. This doesn't happen, by definition for kind of lower level stuff.
It just strikes me as such a huge question to try to answer about such a young person, about their future and their ability to be rehabilitated and it feels like a sort of impossible question to answer, to know for sure. And that must be a really, I don't know, can you comment on that, on how difficult that is from the judicial bench to say, I know what's going to happen in the future for this kid?
Yeah, I'm glad you asked that question, because it is an humbling and sometimes overwhelming sense of responsibility that you have to pull out essentially sometimes a crystal ball and try to look into this crystal ball and see what may or may not happen. Yes, the stakes are high when you're making a decision like declining jurisdiction, as I have in my career. And again, I'm not commenting on that case or anything related to that case. But it also happens with even day in and day out decisions of whether to detain a young person, not just for homicide but for assaults that really hurt people, or property theft which really injures people, and you're looking at a million different factors, and you're doing your work. The law. You're looking at all the training materials from lawyers, advocates, academics, specialists. And then at the end of the day, you're looking at very particularized information about this young person. You're looking at the detention notes, what the state alleges. There are juvenile probation counselors who issue reports. You're looking at educational records. You're looking at notes left by prior judges who might have crossed paths with this young person and what they may have said to that judge at the time. But at the end of the day, you're making very difficult decisions, which affect both the public, could affect both the public, their safety, and it affect the life of this young person, because you don't want to release people who are a threat to the community or to themselves or to others. But you also don't want to unnecessarily detain young people, because you're removing them from whatever support structure they may have. You're removing them from their families. You're removing them from their schools. If they have a family, if they have a school, you're removing them from the life that they know, however good or bad it might be at that moment. And that's a big deal. And so these decisions weigh heavily on the judges, and not just the big ones like declining jurisdictions, but the day in and day out decisions of whether to detain a young person. So yeah, it's intimidating, but it's what we need a place for people who are going to be neutral, objective, and just try to do the work. We need a place for people to make these decisions. And we're privileged, to be honest, to be judges and to make those decisions. And whether you get criticism at the end of the day, that comes with the job. But I don't know a judge who doesn't take it seriously.
I'll have to pause for a short break. You are listening to Soundside on KUOW. I'm Libby Denkman, and I'm talking with Judge Mike Diaz, who serves on the State Court of Appeals. He's a former chief judge of Seattle's juvenile court, and he also teaches law at Seattle University School of Law. He is walking me through how juvenile court works and the major differences between that and adult court in the wake of the mass shooting at Seattle Center. The one suspect who is in custody is just 15 years old. We're going to have more after a quick break here on KUOW. Welcome back to Soundside. I'm Libby Denkman. Jumping back into my conversation with Mike Diaz. He's a judge on Washington State's Court of Appeals. He's a former chief judge of King County's Patricia H. Clark Children and Family Justice Center and an adjunct professor at the Seattle University School of Law. He also taught juvenile law at the Washington Judicial College. We're talking about the workings of juvenile court. One suspect in the shooting at Seattle Center that claimed 3 lives over the weekend is 15 years old. We don't know yet how prosecutors are going to proceed with this case. An arraignment is scheduled for Thursday. Judge, in cases like this, if prosecutors do ask to move things to adult court, what kind of difference could that make for a young person, say a 15-year-old who is tried for a serious offense like manslaughter or murder? How much does it matter for how long they might stay in detention, how long it might be before they might get parole? I mean, ultimately, what are the stakes for the judge's decision on whether to keep them in juvenile court or bump the case to adult court?
Yeah, there's a big difference. The juvenile quote-unquote death penalty, and obviously there's no death penalty for juveniles under our U.S. Supreme Court law, but the quote-unquote death penalty is you can detain a young person under a juvenile charge until age 21. There is no limit. On the other hand, if it's a homicide, it could be life without parole in our state. And so it is a massive difference. I will say that's on the black letter law. There has been a series of cases, beginning now 20 years old, beginning with the U.S. Supreme Court, which have laid out that juveniles are different, that the brain science, that their development have shown us that on some level, in some ways, for some kids, they're less culpable. Young people are more subject to peer pressure. They're more subject to erratic behavior. And I know that we say
impulsive thinking. They're teenagers.
Right. Some of them are. For some kids who develop at a different rate, some of those kids are showing premeditated behavior and that sort of thing. So I can't prejudge and we can't generalize completely. But the science and our own lived experiences, well before the studies came out, we all knew that kids are, make less good decisions when they're teenagers than when their brain develops later on or when they mature. But that has been memorialized essentially by the U.S. Supreme Court and then by our courts in the state here, our state Supreme Court as well. So we treat kids differently, so that if the young person can show that their crimes were a result of youthfulness, and again, that's a legal term of art, which means a lot of different things, then a court can consider whether or not to sentence them in a different way. And that's both in adult court and in juvenile court. But again, that kicks off a very fact-intensive inquiry about, are the facts of this case, was there premeditation? Were there actual juvenile pressures? Were there other signs of some sort of developmental delay in the act itself? And then also, again, looking at the kid's background, what support structures did they have? Family, poverty, all these other adverse childhood experiences that might account for this, which make them in some sense less culpable. Our criminal laws are set up to punish people according to generally in a standard way, but also particularized way, addressing the person who committed the crime or the offense particular to their situation. That's what we would want if we were ever accused of a crime. We'd want someone to understand what exactly was going on at that time in our lives when this was going on. And that's what juvenile courts, I think, generally can excel at. They can excel at digging deep into this kid's life. And now our Supreme Courts, both the state and federal, recognize that that is an appropriate inquiry for a young person who's being accused of very serious crimes.
So for a kid who's accused of something like murder, manslaughter, they stay in juvenile court at the age of 21, that is the end of any kind of detention and also court supervision or further services that can go on? Or are there some kinds of check-ins or, again, like supportive services, things that can be maybe accountability measures that are not detention after the age of 21?
Yeah, so that is generally true. There are some crimes that will require check-ins and community custody, it's called, after age 21. And it's usually not as black and white. You can have overlapping crimes. You can have overlapping systems of accountability, and so there's some extension. And importantly, even when a young person is tried in adult court, they can be held under our state statutes, with the juvenile population till age 25. In other words, essentially an adult is being treated like a young person till age 25 for detention purposes. Under the same theory that we're trying to rehabilitate this person, we're trying, as I've said a million times to a million kids, we don't want them in these courts. We don't want to see them back here again. So that's the goal. And that is both satisfies public safety and rehabilitation. We're trying to get them the services, the supports they need to get them to not come back and not hurt anybody else in any way. That is also, in my experience, what the vast majority of victims want. They don't want this repeated. Obviously, they want accountability, but they also don't want this repeated. And so it gives it doesn't satisfy all victims, but it does give some meaning sometimes to what some awful things that have happened. And again, I'm not talking about necessarily homicides and completely life-altering things, but in other types of cases, seeing a young person being able to be rehabilitated when they had no chance before, and to have some part in that is a weighty thing, and we don't know how many crimes we've avoided by providing these services, but we know that our community is slightly safer, at least because of the interventions we did, however awful the reason for the intervention was.
Before we go, I kind of want to zoom out here and talk to you, Judge, about the issue of gun violence among youths in general. This is something that's obviously been in the news this week because of what happened at Seattle Center, but the Rainier Beach High School murders, also very jarring and tragic loss of life for young people and allegedly committed by a 15-year-old. There's been a series of shootings over the last several months in Seattle. And the question is, how do we get teens to stop picking up guns, or how do we keep guns out of the hands of teens, especially in a society where we have so many firearms? And I wonder if you have any perspective on that, just from your view of the criminal legal system. What can be done to stop gun violence among teenagers?
It's extraordinarily complex question. And unfortunately, sometimes the courts sit at the very end of these processes, right? We only see those cases when a young person is possessing a gun that no young person should possess a gun, obviously under law, both federal and state, but no young person should have a gun. So it's an extraordinarily complicated question. I'll say, kind of similar to what I was saying before, that when we are confronted with these cases, we in a very scientific and rigorous way would try to get at the root causes of what is going on with this person's life, such that they had the need or the desire or even the ability to get a weapon like that. So we here in King County, we're lucky to have just some incredible PhD level type clinicians and psychologists to talk through them and to assess, even at the beginning of the case, if the kid and the family and defense counsel are willing to assess whether or not this young person suffers from things like, for example, PTSD, or from, some paranoia disorder, or, even simple, there is no simple, but, some depression of some kind that is pushing them to want to have a gun, to have negative social relations, to use drugs. And then for the first time ever, sometimes in these kids' lives, to offer them services to help them work through those challenges, to address the root cause of the behavior. And that is just one tiny part, the mental health component of this. It often also comes with, educational supports. And we have incredible nonprofits around our area that help a kid ensure that they're getting the educational services they need. We provide housing. The King County courts even provide clothes and food and taxis, right, to let them get from these appointments. And they're assigned a juvenile probation counselor who, again, with the court, under the supervision of the court, is kind of playing air traffic control through all these services. One of the things that the court's been better about too, though it's not perfect in any level, is also providing similar services to victims of these crimes, because there often is overlap between a person who's a perpetrator and a victim. You might be a victim one day and a perpetrator the next day.
That's the issue of retaliation and cycles of violence that we've been discussing in the wake of this Seattle Center shooting.
Exactly. And so you can't just treat one part of it, and just like you can't treat just one part of the kid's issues. And to reiterate, this is both pro-public safety and pro-rehabilitation. The more you can address the root causes of some of these issues, at least in individual kids, and that's the only way the court can see them, just one kid at a time, the more that you're preventing, hopefully, future crimes down the road, at least from that one young person. And so that's, that limited role at the end of a lot of perhaps societal injustices, at the end of a lot of trauma that both victims and respondents or defendants are facing. The court has one part to play, but like you said, so do community members, so do schools, so do friends and neighbors, and it really becomes a more holistic view when you realize, on some level, we all need to address these young people's needs. And that way we can all, live more safely, live more freely. And again, I'm not commenting on any particular case, but just generally, when we address these young people's needs at the earliest possible stages, we're all going to be safer, and these young people are going to be able to live up to their potential in a way that some of them aren't right now.
Mike Diaz is a judge on the Washington State Court of Appeals. He formerly served a term as the chief juvenile court judge in King County. He's an adjunct professor at Seattle University School of Law and taught juvenile law at the Washington Judicial College, which basically trains judges. Thank you so much, Judge, for walking us through sort of the way juvenile court works, the way it differs from adult court, and some of the considerations that listeners might be wondering about because of, again, the shooting that we are covering out of Seattle Center, 3 dead and multiple wounded, 15-year-old suspect expected to be arraigned on Thursday. Thank you very much, Judge.
Thanks so much, Libby.
Thanks for listening to Soundside. Don't forget you can listen live on KUOW 94.9 Seattle at noon and 8 p.m. Monday through Thursday, or anytime right here online at KUOW.org, or of course on your favorite podcast app.